All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CV21-0211, Thomas Gibbons versus Kodiak Concepts, LLC. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Please remain, if counsel will remain at your tables for argument. We have the microphones, as you can see, installed there at each of your stations. You may remove your masks, which I see that you have done, if you feel comfortable doing that, but when you move about the courtroom, please wear them. Also, we have read the briefs and have discussed the case in conference. And counsel, you may proceed.
Thank you, Your Honor. My name is Mick Levine. I represent the plaintiff appellant, Mr. Gibbons.
Oh, counsel, let me mention one more thing. For appellees, we have counsel for 8090 and counsel for Kodiak. And so how do you wish to proceed? Do you wish to split your time, or will one be speaking for both?
We're going to split the time evenly.
Perfect. Thank you. Go ahead.
Thank you, Your Honor. So we have two claims here. I'm going to talk about the first one first, the second one second. The first one is 8090 LLC. Essentially, what we have is an agreement as to what the law is in this particular instance. What we disagree upon is what the facts say and how they can be interpreted by a jury. Here, in order to establish a joint venture, you need a contract. You also have to have common purpose, community of interest, and equal right of control, and participation in both profits and losses. What we know about the facts is this. Prior to this incident occurring, the two parties were involved in what they called a partnership. They jointly agreed to purchase a building and run the Great Alaskan Bush Company.
Counsel, let me ask you, 8090 and 5832 did, or their principals did?
Their principals did.
Doesn't that kind of matter?
I don't believe so, Your Honor, because the dealings of these parties, and I'll get into that.
Was there any claim ever here by your client to pierce the veil of these limited entities?
There was not.
Okay.
So what we have is when these folks initially decided to have this partnership, it was the principals who had it, and the principals, what they did was they purchased a building and they ran the Great Alaskan Bush Company. At some point in time, what they did was they, one of the principals, Mr. Hartz, purchased the building and straight out just gave it to one of the other principals. They in turn then incorporated, using an LLC for one and an incorporation for the other.
And that was like 20 years ago.
That was not that long ago, Your Honor. And as far as I recall, the timing of that is in the briefs. Let me just take a quick look back in my brief and see if I can find that information for you.
It was certainly more than a decade ago.
It was some time ago, yes. I believe that was in 1997 that they originally entered into this partnership. Around 2002 was when the property was purchased by Mr. Hart and given to Mr. Gates.
So after it was paid off, so 2002?
2002.
And we're in 2022, so about 20 years ago.
Yes, the time period that we're talking about as far as when these incidents occurred, though, was quite some time ago. This was 5 years prior to now. So let me move forward in the history here. Mr. Hartz, he now runs the Great Alaskan Bush Company. Mr. Gates, he now has the building. Both of them incorporate sort of kind of. There's an LLC formed for one of them. There's an incorporation form for the other. 5832 is the Inc. That's the one that runs the Great Alaskan Bush Company. 8090 is the LLC, and that's the one that owns the building. But as we move forward through time, what we have is an interesting agreement between the parties. What happens is that Mr. Hart says to Mr. Gates, I'll give you any lease that you want. Mr. Gates says, okay, these are going to be the terms of the lease, but they don't abide by these terms. Essentially, what the dealings of the parties are, as represented by deposition testimony of Mr. Gates, is that Mr. Hartz would pay whatever he could when he could, depending upon the economy and how well 5832 Inc. was doing. 8090 would accept that. They never.
Is that the relationship that happened, or was there more compliance with the lease than what you just described?
Well, what we have is the deposition testimony, and the deposition testimony indicates that he would pay when he had money.
No, and I'm asking what then happened. Rent was paid as required by the lease for an extended period of time, right?
The deposition testimony indicates that sometimes it was, sometimes it wasn't.
And then there was a change later where it wasn't strictly enforced. Is your point, you call the lease a sham lease, correct?
Correct.
But to show a joint venture, you have to have a contract.
Correct.
If the contract isn't the lease, I don't see you identifying a contract.
It's an agreement between the parties. An agreement may be oral or in writing.
And
here
by
we
the
have
parties, you mean the principals of those two entities, not the entities themselves?
the entities themselves in this particular instance are operating just like the parties are. So there is an agreement between the parties.
Let me interrupt you there just for a second to come back to a point that I started with. There's no claim that the sort of corporate entity doesn't exist here.
Understood, but the corporations are entirely owned solely by these principals. And so when the principal acts on behalf of the corporation, it's the corporation who is acting. The principal is simply the one directing the corporation.
But it strikes me that is blurring the corporate distinction, and that's why I struggle.
My understanding is that corporations can only act through their principals and agents, and here we only have their principals acting. So if 5832 is going to make an agreement with 8090 LLC, it's made between the principals on behalf of the corporations.
And your point is that can't be the lease because they didn't strictly enforce the provisions.
That's correct. But
And
we
would
can't.
if that argument holds, wouldn't almost every landlord-tenant relationship be a joint venture? I mean, when are lease terms strictly enforced, and when are they almost strictly enforced, and when are they maybe not strictly enforced? Is that really what joint venture turns on?
I don't believe that that's so, and I don't believe that that's what happened in these particular circumstances. In these particular circumstances, the agreement between the companies made by their principals appears to be, pay us when you have money, don't pay us when you don't have money. It appears to be, we're not really going to enforce any of the terms of this lease, we're not going to kick you out, we're not going to lock you out, we're not going to charge you interest, we're just going to proceed basically that you send us some profits when you have them.
Well, the agreement didn't say just send us some profits when you have them. The agreement said this is the rate, it's a sum certain for the lease. Now, the way they addressed it in practice was different, but the agreement itself was there's a sum certain that must be paid.
That's what the lease said. That's not what happened. The practice of the parties, I believe, is what we can show as an agreement between them. These folks didn't actually stick to this lease. What they did was they had a little side agreement. You pay us some profits when you have them. And that's the agreement that we're saying that they had. Not the lease, which is in writing, but rather an agreement by the actions of the parties and an oral agreement to just pay us when you have some profits.
So the actual enforcement.
Right.
Okay.
I think through your questions, I've pretty much addressed most of these issues. The issues that we were talking about as far as what needs to be found here is whether or not they have common purpose and these types of things. And that can be shown that the common purpose here was for them to make money. And that's what they desired to do, was to make money. Both Damien profited from this agreement, both 5832 profited from this agreement, 8090 profited from this agreement, and between the agreement that they had when there were losses 5832 didn't pay 8090. 8090 jointly suffered from those losses. Now, had this been a real lease rather than what I call a sham lease, what would have happened is that 8090 would have locked out 5832 as soon as they weren't paying. 8090 would have charged them interest. 8090 would have required them to maintain insurance on the property. But that's not what happened here.
Counsel, what evidence, the trial court found, among other things, that you didn't provide any evidence that they shared profits. What evidence do you have that these two parties shared profits?
I believe the sharing of profits can be shown in when they paid whatever the alleged lease amount was. So when 8090...
Rent, in your view, at a variable rate is the sharing of profits?
And losses, yes.
How is paying rent sharing losses?
Because they didn't always pay the rent. What they did was sometimes they paid less than what it was that they were supposed to pay under the terms of this lease. So when they didn't have the money to pay what they were supposed to, they paid whatever they supposedly could, and in that regard, they shared in the losses.
Is there any evidence that when the business was doing well and that 8090 was then receiving in excess of what the agreed upon rent was?
And I understand what you're saying, and here's how I understand that the course of conduct between the parties were. There was supposed to be this set amount for rent. Sometimes the set amount for rent was paid. Sometimes the set amount for rent was not paid. When it wasn't paid, they paid less. When 5832 made more money, they made up whatever the amount was that they were in deficit supposedly on the lease. So it's not that they paid over, right. There was a cap, and the cap amount was the amount that they were supposed to pay through the contract with the lease.
And sometimes they paid more to make up for what they had not paid before?
That's correct.
Wouldn't that tend to show that they were trying to keep to the lease as much as the income allowed?
Or it might show that they were sharing in the profits and losses.
Okay.
All right.
Counsel, what about the fourth requirement, the equal right to control?
Well,
What's the evidence?
If this lease provision regarding locking out and what have you was something that
But maybe be more specific. What about the control of the business, the operation?
The operation...
The day-to-day activities going on.
Of 5832,
yes.
Correct. Okay, so what we know is that Mr. Gates went to the property on a few occasions. As far as the day-to-day control, he didn't have any day-to-day control. What he could control, however, was whether or not that business stayed in operation or not. And for a joint venture, I would say that it needs some control, not total control. So we all know about silent partners. That's something that frequently happens where there's a partnership and the partner may have a very involved interest in the business or may not take such an active role in the business. What we do know is that he had the ability to lock them out, but didn't. I'd like to switch gears now to the second one, only because I can see that my clock's running and I want to make sure that I get to it. So our second claim is against Kodiak Concepts, and I want to talk about the purchase agreement. The purchase agreement was listed as an asset purchase, but it wasn't. The asset purchase, the quote-unquote asset purchase of Kodiak Concepts from 5832 Inc. also acquired debt. And they took on a lot of debt. And I know that all the numbers are in there, and I'll just talk about some of those numbers briefly. But they also took on unscheduled debt, debt that wasn't in this agreement to purchase. Some of the things that they took on was $25,000 that they paid to, well, Mr. Gates, 8090 LLC. Another part of the debt that they took on was a private payment to Damian Hart, not to 5832 Inc., which was the company that they were purchasing, supposedly purchasing the assets from, but to Damian Hart himself, personally, not giving money to the corporation in order to purchase assets of the corporation. That amount was, if I recall properly, $193,900. Now, we agree with the defendant's evaluation of this business. It was in the $150,000 range. They paid $193,900 to Damian Hartz for assets of 5832, a business that was only worth approximately $150,000. This is a kickback. That's what this is. This is fraud upon the creditors. This is not money paid to 5832 so that 5832 can pay its creditors. Instead, this is money that is paid directly to Damian Hartz in order to avoid creditor claims, such as our client. So,
Any evidence that at the time of that transaction they knew of your client's claim?
there is not evidence that at the time of the transaction they knew of my client's claim. But as I understand the law in this regard, it only matters that the claim has arisen, not necessarily that they're aware of it.
Well, I think if you're trying to argue that the transfer was improper, it might. In fact, didn't the Superior Court say that he thought your position would have been stronger had you provided notice shortly after the accident?
And I believe that it would have been stronger had there been notice right after the accident. But I believe under Title 44, it's not required. It's only required that the claim has arisen, not that they have knowledge of it.
The Fraudulent Transfer Act, you didn't state a claim for that, did you?
We did not state a claim for fraudulent transfer.
So how does that statute apply here in interpreting a common law concept?
Our claim is that they fraudulently transferred the business.
I thought I heard you say you didn't assert a Fraudulent Transfer Act claim.
Not for, we asserted a claim for successor liability.
Right.
One of the ways that you get to successor liability is that the business is transferred by fraud.
I'm with you.
And so that's how we got through the Fraudulent Transfer Act in order to talk about how it was a fraudulent transfer of the business.
Are those one and the same? Because Teeter's a common law case, right?
Teeter's is a common law
apply
case.
The Act, how does the Act apply for a common law claim?
I would say that the Act is instrumental in demonstrating how you get there. Yes, Teeter's is a common law claim, but the Fraudulent Transfer Act is instructive on what is fraudulent under these particular circumstances. Teeter's did not address the issue of fraud straight out. So in the absence of something talking about fraud straight out, what we did was we borrowed the Fraudulent Transfer Act in order to say this is how you get to fraud under Teeter's.
And what's your best case supporting your common law fraudulent purpose transfer claim?
Well, A.R. Teeter's, unfortunately, like I said, it does not get there, but the Fraudulent Transfer Act is probably the best way that we get there.
And I understand that answer. My question was different. What's your best case decision supporting that theory?
Unfortunately, we weren't able to find any law regarding that here in Arizona. So what we talked about, though, is the badges of fraud that are associated with this transfer. Now, Teeter's talked about another way to get there, too, that we also talk about in our briefing. Kodiak Concepts acquired all of the debt of this company, it appears, with the exception of ours. Ours is the only debt that Kodiak Concepts didn't pay. They took on scheduled debt that was actually listed in the contract. They took on non-scheduled debt, $25,000 to the landlord, $193,900 to Mr. Hartz directly. Ours is the only one that they didn't. A reasonable jury could infer that they intended to take on all the debt of 5832 when they purchased it, because they took on everything, whether listed or not, in the purchase agreement.
And what provision of the purchase agreement do they say they took on all debt, even if it wasn't listed?
They didn't.
Okay.
But
I read
by
the
act,
contract
that's what they did.
I read the contract the same way.
Yeah, they didn't specifically say so in the contract, but that's what they did by actions. When they took on the $25,000 from the landlord, that wasn't in the contract. When they took on $193,000 to Damian Hartz, that wasn't in the contract either.
And they said in the contract that their intention was not to take on anything that wasn't specified in the contract.
That's exactly right. They indicated in the contract they weren't going to take on anything else that wasn't specified in the contract, but they did anyways.
Were they forbidden from doing so?
Under the terms of the contract, I would say that they weren't supposed to take on any debt other than that was scheduled, but they did anyways, everybody but us. And so that's how we get to not necessarily that they specifically said that they were going to take on our debt, but it could certainly be inferred by a jury that they were willing to take on and going to take on everybody's debt, regardless of whether it was scheduled or not scheduled. I see that my time's almost out. I'm going to try and reserve the 58 seconds I have left. Thank you.
All right, thank you, counsel.
Thank you. Good morning. Elizabeth Garcia for defendant in Appellee 1890 LLC. I believe 1890 LLC's answering brief sufficiently discusses the issue relevant to my client. But in the 10 minutes allocated to us, I'd like to briefly touch on two issues. First, whether the sham lease theory arguments plaintiff makes in his reply remedy his failure to address all 5 elements of a joint venture in his opening brief, and second, 1890 LLC's request for attorney's fees. At the outset, I'd like to note that Gibbons doesn't dispute that a joint venture cannot stand where even one of the elements is missing. He also doesn't dispute that his opening brief didn't address the community of interest and participation in profits and losses elements of a joint venture. He didn't develop argument on the common purpose element. Instead, he filed a reply which argued that his sham lease theory satisfies all 5 elements, even the ones he failed to address in his opening brief. By failing to raise and develop argument in his opening brief on each of these elements, Gibbons waived any contention that the trial court erred in granting summary judgment based on his failure to come forward with evidence on these 3 elements. He can't remedy that waiver by arguing for the first time in reply that his sham lease theory satisfies all 5 elements. This court has long held that arguments made for the first time in a reply are waived. They deprive the opposing party of an adequate opportunity to respond. Now, to the extent Gibbons might suggest, well, my reference to a sham lease in the opening brief is sufficient to preserve these arguments, they weren't. I'd like to note that that sham lease theory in the opening brief was raised in the context of arguing that a partnership, that is a contract or agreement, the first element of a joint venture, was satisfied. He didn't argue that it also satisfied the profits and losses and community of interest elements of a joint venture. In analyzing the facts adduced in the trial court, for the first time, on appeal, Gibbons argues that, well, now there was a contract, an oral contract, a side agreement. But I'd urge this court to refer back to Index of Records 63 and 64. There was no evidence, much less an allegation of any oral agreement or side agreement adduced in the trial court. Gibbons now admits that the lease itself isn't the contract that satisfies the first element of a joint venture. He's instead somehow suggesting that a 1997 partnership that existed between Damien Hartz and Richard Gates somehow satisfies this first element of a joint venture. Unsupported speculation, unsworn assertions of facts don't get you past summary judgment. He still hasn't identified any contract that 1890 LLC and 5832 Inc. agreed to operate a gentleman's club in 2016 when the accident occurred. Even if he hadn't waived the sham lease theory, he also hasn't identified that 1890 LLC and 5832 Inc. had a common purpose or community of interest to operate a gentleman's club. The interest in making money is common across all businesses. That doesn't render the business's purpose or interest as being common. Otherwise, every single business, every single landlord, every single tenant would have a common interest. By admitting that 1890 LLC was paid rent and received its funds through the payment of rent, Gibbons has implicitly admitted that the purpose and interest of 1890 LLC was to make money by leasing property, not to make money by selling consumable goods or entertainment, which was how 5832 Inc. operated, and that was its purpose, that was its interest.
Counsel, let me ask
yes.
you, we had two waves of summary judgment, one of which involved your client, one of which didn't. Both those were after discovery was complete, correct?
That's my understanding.
Thank you.
Counsel, what about, speaking of the lease, what if it's a one-sentence lease that when business is good, you pay me. When it's not, you don't need to pay me.
I think I'd refer back to the corpus juris secundum. I couldn't find any authority in Arizona case law specifically identifying that fact. But
Doesn't that
the
sound a
principle,
lot more like a joint venture?
I would say not, because
Why not?
to establish a joint venture, you still have to have some element of control. So the mere fact that rent might be premised on the success and the profits that a business might make doesn't bring it any closer to a joint venture where the landlord has no control over the actual operation of the tenant's business. So that moves us to the third point, the sharing of profits and losses. Paying rent isn't sharing in profits and losses, even where a tenant might be unable to meet their month's rent commitment due to financial struggles or, a family member with a drug addiction who was allegedly stealing. I would like to really urge this court to refer back to Gates's deposition testimony. IR 72 is the most complete version of that testimony. He didn't say rent was always premised on profit. He testified that there was a lease that set a schedule and that the long-term tenant started playing catch-up and had various excuses for why they were playing catch-up. That they were, in fact, attempting to remedy the underpayments that they had made previously shows that the lease's obligations were serious and that they had to meet those obligations. And finally, the last element of a joint venture also hasn't been satisfied. There's no evidence that 1890 LLC had equal control over the operation of the Gentlemen's Club. Gibbons has admitted that Gates had no control over the day-to-day operation of the business. He only hinges this argument on the fact that, well, they could have evicted 5832 Inc. for failing to meet all the lease's obligations. That's always true of a landlord who has a lease with a tenant. That doesn't mean that the landlord has control over the operation of the tenant's business. There's no evidence in the record that 1890 LLC had any control over the hiring, firing, training of 5832 Inc.'s employees, that it admitted had any control to admit or decide which customers were going to be admitted to the premises, or that it had any control or say in whether a particular customer would be served any alcohol, much less a specific quantity of alcohol. So there's no evidence in the record of any of the 5 elements of a joint venture, notwithstanding Gibbons' failure to preserve on appeal argument regarding 3 of those required elements. Just as he failed to do in the trial court, Gibbons has failed to come forward with evidence that creates a genuine issue of material fact on the joint venture claim, and for that reason alone, the sham lease theory fails. Now finally, 1890 LLC should be awarded its attorney's fees and costs for having to defend against this frivolous appeal. The trial court made clear.
So how did the Superior Court deal with fees? Did the Superior Court award attorney's fees?
I'm not aware of whether attorney's fees were awarded in the trial court.
Are you aware whether they were requested?
I'm not, but I can look at the record and file a supplement if this court desires.
Okay, I was just curious. I mean, so you're really asking for fees for the first time on appeal?
As a sanction. Just yesterday, this court issued a decision affirming that when a frivolous
Just
appeal...
under RCAP 25, not 349?
Correct. That is the basis for this fees request. This appeal was undeniably frivolous. It was made abundantly clear to Gibbons in the trial court that failure to even come forward with evidence on one element causes a joint venture theory claim to fail, and he still chose to file an opening brief that didn't even address 2 of those elements. That he's now come forward in his reply with a sham lease theory and arguments in all 5 elements doesn't remedy that failure. This court can only affirm where the plaintiff has waived argument on 2 required elements of his claim. Now, waiver notwithstanding, this court should also affirm and find this appeal frivolous because on this record, where there was no evidence of each of the 5 elements in the trial court, a reasonable attorney would have known that this appeal was not meritorious and that the trial court's grant of summary judgment could only be affirmed. Accordingly, 1890 LLC respectfully requests that this court affirm the grant of summary judgment and award it its reasonable fees and costs as a sanction for having to defend against this appeal. Thank you.
Good morning. May it please the court, my name is Pete Shellstraight. I represent the defendant, appellee, Kodiak Concepts. The only thing that Mr. Levine said that's relevant is the fact that the fair market value at the time my client had the transaction of purchasing the assets was, we agreed the fair market value was what our expert that we hired came to, was $150,000. You cannot have a claim. A creditor cannot have a claim unless they've been detrimented for either fraudulent conveyances or successor liability. If their position has been improved, what claim do they have? If my client didn't purchase the assets of 5832, and instead of waiting 2 years to file the complaint in this case, they got a judgment right away a week after the accident happened, and they went down and they went to collect on their judgment for 5832, they would have to wait in line behind all these other creditors. Instead, with this transaction, my client, assumed the debt and paid off these other debts. Whether they paid to the landlord because they had to have a lease to operate at that location, so they made a payment to him, or they paid to Damian Hartsey because he wouldn't go away and he wouldn't comply with the rest of the deal, that's irrelevant. What's his argument going to be at the Superior Court? That my client somehow bribed Damian Hartsey to sell the assets of 5832 for way more than their fair market value? I mean, that's ridiculous. And that's my client's case in a nutshell. Everything else he said, you don't even get to that point. My client improved the situation for him and his client. I mean, they should be thanking us, not suing us. And if you have any questions for me.
All right, thank you.
Okay, thank you.
According to my timer, I have 56 seconds left. So as far as the attorney fee request, this is the first time that it was made, and additionally, I don't believe that the attorney fee request is appropriate given these facts. The plaintiff has shown the arguments that he made regarding the sham lease, and what the plaintiff's arguments aren't frivolous. While it may be asking for an extension of the law, we're permitted to do so here. As far as the last argument that was made, I don't see that this is the situation where we should be thanking Kodiak Concepts. I don't understand the argument that Kodiak Concepts has improved my client's position at all. What we do have is that this deal had some elements of fraud to it, especially the $193,900 payment straight to Damian Hartz that avoided creditors' claims.
Thank you, counsel. Thank you. This matter, first of all, we thank you for your arguments, all three of you. The matter is now taken under advisement and will issue a written decision in due course. We're at recess.